Well, good evening, everyone. Welcome to this evening's plenary lecture to be given by Professor Julia Hornle of the Centre for Commercial Law Studies here at Queen Mary, University of London. My name is Simon Gaskell. I'm President and Principal here at Queen Mary, and so I have the pleasure of welcoming you all, and it's great to see such a large audience. These inaugural lectures are not simply opportunities for us to dress up in our finery, but are, of course, a celebration of talent that we have amongst the professoriate at Queen Mary, and also an opportunity to make sure that that talent, if you like, is more widely advertised outside the institution. And my job this evening is very simple, because we have, I'm pleased to say, an external chair of the evening, and so my job will be done in just a few moments, but I will spend just a couple of minutes introducing that external chair, whom we're very pleased to have with us. Our external chair is Peter Johnson, who is the Chief Executive of the Authority for Television on Demand, with the rather inelegant acronym of ATBOD. He has been in that position since its designation by Ofcom in March 2010 as the co-regulatory authority with responsibility for editorial content for our on-demand programme services. And in this role, he was responsible for ensuring that UK video on-demand services complied with the requirements of the Audio-Visual Media Services Directive as they apply to editorial content. Following the decision by Ofcom to take video on-demand regulation back in-house at the end of 2015, he is now overseeing the wind-down of the company as an independent entity. He was previously head of policy and business development at the British Board of Film Censors, film classification, where he was responsible for all aspects of regulatory policy and research, and for the development of new classification services for both packaged media and video on demand providers. So we have the privilege this evening of having an expert chair of our session, as well, of course, as an expert in her own field in Professor Julia Hornle. But without further ado, I hand over now to Peter Johnson. Thank you.
Well, first I'd just like to say what a pleasure it is to be here to chair this session for Julia. It's also a novelty for me. This is the first time I've ever worn an academic gown, having boycotted my own graduation ceremony 30 years ago for reasons which I'm sure were very good at the time, which I can no longer remember, but it was the 1980s. Mainly, however, it's an absolute honour to be able to do this for Julia, who is a real leader in thinking about the legal implications of our human interactions via this extraordinary phenomenon that we know as the internet. Her work in this area is very much that of a pioneer. The world she's grappling with may impact on virtually every aspect of our lives, our banking, our shopping, our dating, everything that we do. But it's also very, very new. It's easy to forget that, Sky only became an internet service provider in 2005. Facebook only opened up to everybody in 2006. The iPhone and the iPlayer only launched in 2007. The iPad didn't exist before 2010. And Tinder and Netflix only launched in the UK in 2012. I know there are young people in here who will be thinking that's ages ago. Believe me, that is very, very recent. Now, working in such a fast-paced area would be daunting for many people, but it's certainly not for Julia, as her many achievements demonstrate. She is a widely recognised expert in a whole range of areas: internet law and jurisdiction, internet dispute resolution, internet regulation itself, online gambling regulation, online consumer protection, and privacy and data protection online. Her publications include books on both cross-border online gambling and cross-border internet dispute resolution. I think that cross-border element is at the heart of her lecture today, and her academic articles really are far too numerous to mention in a short introduction. But individually and collectively, they have long marked her out as an academic of very high standing in her chosen field. Of course, being an academic also involves teaching, and Julia has been Programme Director of Postgraduate Teaching at CCLS since 2013, having been Programme Director of Computer and Communications Law, LNM, by distance learning for many years before that. And last year, Julia had the honour of being visiting professor at the National University of Singapore. And I know there are many of her students here this evening who will attest to her qualities as a teacher. Julia's also been highly successful in securing funding for important PhD research projects in areas including cybercrime, terrorism and the internet, children online gambling and online advertising and consumer behaviour, key issues that touch all of our lives. She's also undertaken important research for the Department of Business, Innovation and Skills on the state of play on online consumer redress in the UK and consumer protection and law enforcement cooperation across a range of jurisdictions. No surprise then that her expert views are widely sought. She was a member of the Civil Justice Council Advisory Working Group on Small Claims and Online Dispute Resolution, whose report was published in February last year, and is currently leading expert for the ongoing Council of Europe project on Internet Dispute Resolution. But I know her best in a non-academic role, from her 4 years as a director of the Authority for Television on Demand. And in that role, I think she demonstrates what, for me, are some of her key strengths. Her recognition that law has a real impact on real people and real businesses in the real world, and her willingness to expose her own expertise and test her own judgment in a real-world regulatory environment, something which she did exceedingly well. In that non-executive role at AVOD, an ugly acronym, but I'm afraid we were saddled with it, Julia seized the opportunity to be at the heart of our decision-making in the most difficult areas faced by the new regulator, deciding which services met the definition, the statutory definition of an on-demand programme service, a process which one of her colleagues described as like nailing blancmange to a wall, turning as it does on such questions as how like a TV programme must the programme be to be considered TV-like? Now, thanks to Julia's expertise, some of that blancmange stuck, and that enabled us to regulate for the past 6 years. Julia was undaunted by that task and stepped up to chair the relevant decision-making committee and presided over those decisions that defined our regulatory remit. And for guiding me and my colleagues so expertly through that minefield, I'm eternally grateful to Julia, and it's therefore my pleasure and privilege to be able to introduce inaugural lecturers, Professor Unclaimed Territories in the Clouds, Where Are the Limits to Internet Jurisdiction? Professor Hornle, over to you.
Unfortunately, the system has gone to sleep, so as computers are, I have to wake them up. So the lesson from this is you should first do the computer and then the screen. But never mind, we're there. First of all, I've been quite brave because I was recommended to use a new presentation system which I haven't used before, and I'm testing it in my inaugural. And it's actually, as you will see, we'll have some air sickness bags if you need any. So this will become clear as I go through the presentation system, why I'm saying that. Well, first of all, of course, an inaugural is an opportunity. Actually, is the sound okay? I have a mic on here, actually, which I switch on because it's recorded as well. So this should be better. Yes, I think it's a different sound. Okay, great. So an inaugural, of course, is an opportunity not just to look forward, but also to look back. And first of all, I want to express really my thanks to my mentors at the Centre for Commercial Law Study at Queen Mary University of London, Professor Ian Walden and Chris Reed, who supervised my PhD, and have supported me throughout the years, really, within my career. And actually all other colleagues at CCLS, where I think we have extraordinary good teamwork, which I think is not always taken for granted at university. What has really, in a way, been a sort of current theme throughout my career was this question, and in a way this contradiction, between the internet being a cross-border communications medium, but law being mainly territorial. And how do you actually square the two? Most lawyers, of course, think everything is kind of governed by law, and obviously not all life necessarily is governed by law. But I think for a lawyer, this is really the key question, because clearly jurisdiction is one of those things we take for granted, but on the internet, it doesn't work very well. So this is basically the conflict I want to look at today. So on the one hand, laws are governed, territorial laws by nation state are governed by the principle of jurisdiction, which basically restricts a state's power to its territory. It allows, on the one hand, the state to exert power over its territory, people and assets, but it also restricts the state, strictly speaking, to that territory. Now contrast that with the internet, and I think more modernly in a way the idea of cloud computing, which essentially enables the unhindered flow of information across borders, regardless of borders, which by definition causes conflicts of law. And how do we deal with these conflicts of law? So in a way that is the core theme, I think, of my work and the course of this lecture. Now what is jurisdiction? Well, on the one hand, it's the power of the state to act. So legislators to pass laws, powers of regulatory authorities and the police to enforce these laws, as well as judges and the judiciary to make decisions about these laws. And all of these, of course, are bound to the territory. So the territoriality principle, which is the principle under international law and national law, is the idea that the state has to show a link with the territory before they can act. Now, the territoriality principle is not the only principle on which states assume jurisdictions, but for common law countries like the UK and the US, the territoriality principle is the main principle of jurisdiction. Now, there is obviously a history to that, and actually I went to the British Library and so reading some of these old books, because I'm actually writing a book on this topic at the moment as well. And it's so easy when you're an internet lawyer, history is 2, 3, 4 years old maybe, but of course law's history is much, much older, so actually this history is relevant. And it's quite interesting that the territoriality principle was really seen by the Enlightenment in the 17th and 18th century as a key principle. In other words, a governor should only have power over the people on their territory. So in a way, the idea that that a state owns its subjects and the law follows it across jurisdiction was actually seen as a negative. So the idea really was that subjects voluntarily enter into a territory and therefore are governed by the laws in this territory. Also the idea of a social contract, such as Rousseau, for example, the idea that part of the social contract means the ruler governs people on their territory. Now, on the internet, how does this work? So we have someone in the country green, sits on a bench in a park and hacks into a computer, stealing payment card details, and then uses these payment card details to cause damage in the brown territory. So which, in a way, which territory has jurisdiction here? And I think this example shows that clearly the territoriality principle is not exclusive. So the way the territoriality principle usually is used is that you only have to show that one constituent element of the crime has to happen on the territory. Now this can be the hacker sitting on a park bench and actually acting in the territory, so the green land, or it can actually be where the data is being used. So obviously depending on how the offence is defined by national law, whether a state can assume jurisdiction. Now, the other thing about the territoriality principle is that it's a dual-edged sword. And a dual-edged sword basically means you can hit both ways. And so on the one hand, it gives the power, the state the power to exclude other states by saying, this is my territory, stay out. But it also limits the state. So the state says, well, we only regulate on the basis of territory, limits its own power to go beyond that territory. And I think we see that, for example, if you look at some of the US law, there's a sort of presumption that the Congress only enacts laws for US territory. And that was kind of used against, especially the UK, you know, if you go back again in history, in the early 1800s, stay out, this is our territory. But these days, I think, where the US in many occasions wants to assert more extraterritorial jurisdiction, in a way, this presumption kind of gets in the way of that. Now, is the territoriality principle sufficient? Now, I show here a slide of Germany in 1648, and I think this slide to me shows that, in a way, the territoriality principle isn't sufficient, because if you committed a crime, say in Württemberg, the yellow area, then you might very quickly nip over to the red area, and then if the red area hasn't got any jurisdiction, then it's very easy to avoid the state's power. So on the continent, unlike common law jurisdictions, there is a tendency to use other principles of jurisdiction, such as the active personality principle. So, for example, in a German criminal code, Germany can assert jurisdiction over a German national, even if the crime wasn't committed on German territory. And there are various other principles which I don't have time to go through. It's kind of interesting that in earlier times, so if you go back to the 14th century, for example, a lot of the legal writers were actually advocating for the personality principle. In other words, the law follows the subject rather than the territory. And the interesting thing, I think, is that with the internet, we're returning to this. So we're almost returning to the medieval world, where actually it was the personality principle which governs people's actions. Oops. Now, of course, perhaps this isn't about jurisdiction at all. States can write in their laws what they want. They just make sure that the constituent elements of the crime, for example, happen on the territory. But the real question then is, if you make a law, can you actually enforce that law? And that, in many ways, is a very, very practical question, because you can only arrest someone if the person is actually in the territory, unless obviously you kidnap them and then transfer them into another territory, which occasionally, of course, happens in history. If you think of the Iceland trial. But it's rare. So enforcement as a matter of principle requires a person or some assets, some property on the territory. And the other aspect, I think, which is interesting here is, of course, the avoidance of jurisdiction and regulation. Because clearly a company who doesn't want to comply with the law would establish themselves in a country where the least standards of regulation, because then they don't have to comply, it's difficult to enforce. We obviously have seen that in various areas, including tax. So essentially, jurisdiction, the territorial principle, is about the place where the offence is committed. That you need to show a link with the territory, but that link can be shown by any constituent element of the crime. So in some ways, territory perhaps is not such a limiting factor. It's enforcement which perhaps is the relevant limiting factor. So now focusing in on the internet, what has changed? Well, first of all, the internet enables remote communication. It has done so from the beginning. That's the whole point of the internet, that you can actually access a remote resource, which is in a different location. That's the wonderful thing about the internet. Then we saw obviously more and more the development of the interactive user-generated content, where everyone is a publisher, and you don't really care where the people are reading Facebook comments. Again, that's the beauty of it in many ways, but in terms of legal jurisdiction, that obviously can cause problems. Greater bandwidth, always on, we now live with our mobile devices, of course, and then the next step, in a way, in the last 5-6 years, cloud computing. So not just do we access remote resources, which is what the internet is allowed, but we also, in a way, don't store any data on our machines anymore. So the user these days doesn't store any data or software on a computer. They use remote services which can be bought in as a utility. You only pay for the services you use. You don't have to pay for an expensive license. If your business shrinks, it's just more efficient. You buy in these services. And of course the data isn't exactly in the cloud. It is called cloud computing because it's so difficult to find the actual territory in which the data resides. But of course the data isn't in the cloud, it's in a data center somewhere. But the whole point is that you don't always know where that data and the processing takes place. And there are layers and layers of service providers, all contractually linked, but they might well be in different countries. So vast amounts of data crossing national borders, the location of the data is unknown, often, not always. It's difficult to establish the identity and location of the sender and recipient. So that is, I think, what the technology is about. So this has the following consequences. First of all, it's unclear what constitutes the relevant territorial link. Is it the fact that the data center is in that country? Or is it the fact that the person who controls the data is in the country? And they might well be two different countries. It could lead to overlapping jurisdictional claims, so several states assuming jurisdiction over the same activity or the same crime. And ultimately it means that states cannot enforce all their laws. They might be able to enforce some of theirs, but not all. So this can be illustrated by some of the cases which we've seen before the criminal and civil courts recently. I'll just pick out one which I think is a good story. That was the case of Mr. Tobin, who is a revisionist historian who wants to desperately show that the Holocaust never happened. He's an Australian citizen, mainly domiciled in Australia. Of course, he travels across the world, but he had a website which contained Holocaust denial materials. And he went to Germany to promote his course in commerce, was handing out leaflets, and in Germany that is a criminal offence. So he was arrested and charged. But the question was, before the Supreme Court, whether Germany has jurisdiction to try Mr. Tobin, not for the leaflets, but actually for the website, which was hosted, operated, and created in Australia. And the German courts, and he's an Australian citizen, so the German courts were saying, well, this is obviously a horrific part of German history, and hence his activities are in a way directed at Germany. And that was the relevant jurisdictional link, because it could affect public order ultimately in Germany. So on that basis, the court ultimately found that Germany has jurisdiction over this website, which was hosted and operated in Australia. So I thought I'd present 4 different examples, which obviously kind of reflect the type of work I've done over the years. The first one, of course, is e-commerce, in particular business to consumer e-commerce. So obviously you all shop online. When you shop online, of course, you have a contract. That online contract is governed by terms and conditions. But of course, no one ever reads the terms and conditions. This is terms and conditions of iTunes, which are, I think, 47 pages, I can't remember. And how many products do we make every day? Well, but the law nevertheless maintains a fiction that as long as we have the opportunity to scroll through these terms and we click I agree, we do actually agree. So one of the concerns here is, and I have to apologize about this map, because this is the trouble with this zooming technology. I actually located the London Royal Court of Justice, I think, in the Pyrenees. The point I'm making doesn't really matter. So we have a consumer, say, in Chile, who transacts with a business in the UK. Of course, the UK business will try to incorporate their terms, which mean that most likely the English courts have exclusive jurisdiction and English law applies. So is there obviously a concern for the consumer that if things go wrong, they would have to come from Chile to the UK to actually sue? Now in Europe, because of this concern, we have changed our conflicts rules in 2001, that we informed recently, which basically says that if a business directs their activities to the consumer's jurisdiction, then the local court of the consumer has jurisdiction. So to some extent, European law addresses this particular issue, but the problem as such obviously still stands in the room. The other question, of course, is even if our consumer in Chile would go to their local court and they win the case, they of course still have to enforce the resulting ruling against the English business in England. So there are still enormous costs involved in enforcing the judgment. So perhaps formal court procedures are not the right solution here, so maybe we need to develop more international consumer dispute resolution, and that is, in a way, one strand, one interest of my work. So I looked at some of terms and conditions, and it's interesting that some of the big US corporations we all buy from actually comply, unsurprisingly, perhaps with European law. So clearly Amazon recognizes that consumers can bring claims in their own courts. iTunes, you choose where you're from, and then it says that English law applies. But for example, in the Apple, the 47 pages, which I earlier showed, somewhere in there, after Snowden, that's no surprise to you, it also says that Apple can disclose, without liability to the user, any information to any law enforcement as they need. So this is perhaps for a lot of consumers surprising, perhaps a worrying development, which we've seen in the Schrems case, for example. And then I looked at some smaller American companies. The interesting thing is that in the US we see a move from obviously using arbitration over litigation, because that means that there's no class actions from the US point of view. So yes, there are some concerns about when things go wrong, especially in consumer cases. Obviously US companies comply with European consumer protection law. Online dispute resolution, I think, is one solution to this problem. But perhaps, in a way, for most consumers, I think the more worrying aspect is this disclosure to foreign law enforcement, which I'll come to in my fourth example. Now, the other area which I think, which is a brilliant study of jurisdiction online, is the area of online gambling. Now, I'm not saying gambling is bad and you shouldn't do it, there's a moral issue, but, of course, many states do.
Yes.
So, gambling is heavily regulated in one way or another. Many states in the world, probably most states in the world, simply prohibit online gambling and leave it at that. So there might be a criminal provision which basically says you commit a criminal offence. But there are differences in regulation. In the UK, with the Gambling Act 2005, we have actually relatively liberalised our system, so online gambling providers simply can get a licence and provide their services in the UK. So online gambling is offered remotely, so again it's very easy in a way to avoid the local law. And this is not a jurisdictional issue from, if you take the viewpoint of the regulator who tries to enforce the protections against gambling. I mean, you might say that there shouldn't be any protections, but that's a different question. And in a way, you could say, well, that's simply an example of applying the law of the destination, because clearly the gambler sits in that jurisdiction. If the state wants to protect their own citizens, jurisdictionally that's perhaps not a problem. But what is the problem is, of course, enforcement, regulatory arbitrage, because at the end of the day, if the gambling operator never goes to the jurisdiction, how do you actually enforce the law? So, and I think the UK is an interesting example of that, because the original act in 2005, quite bravely, I think, provided that you don't need to get a license from the Gambling Commission if you offer online gambling services, unless you have a piece of equipment within the territory. So basically they said, yes, you know, consumers, we can't prevent consumers from accessing foreign gambling sites. So, but of course what happened, and clearly tax is here the main driver. So the main operators, gambling operators, located with Gibraltar, the Isle of Man, Malta, and various other island locations where there was a better tax regime, lower tax, fewer regulatory restrictions, potentially less enforcement costs, less compliance costs. So they left the jurisdiction, and clearly that harmed the UK in terms of tax revenue, because the whole idea was that they would all come back to the UK because we have such a really good system, and therefore consumers would trust them. And that didn't happen, I think mainly driven because of the tax, the cheaper tax. So the Conservative government tried to reverse that by passing the Gambling Act in 2014. So now if facilities which are or will be capable of being used in Great Britain, you have to get a license in the UK. And Malta tried to judicially review this provision, but was ultimately unsuccessful. So I think the lesson here is really about enforcement. So some of the very restrictive anti-gambling jurisdictions try to enforce the regulation of gambling by payment blocking. For example, in the US we have an act in 2006, Norway has a payment ban. So the idea is to basically follow through the payment and then block it. So if you have a gambler, they obviously present a payment card to the merchant, in this case the gambling operator, then obviously there's an electronic communication, automated communication through to the acquirer and the issuer would ultimately block the transaction because of the merchant category code indicating what the transaction is in respect of. And if it's a gambling transaction and the issuer is in a country where gambling is illegal, they simply block the transaction. That's the idea, and that works to an extent. But of course, you can use intermediaries either at the end of the merchant, the online gambling operator, or the gambler himself can use a sort of series of payment intermediaries, which of course in a market like this spring up. So there is a big question on how effective is this system for the regulation of gambling. So I go back one. So the other way of enforcing it, of course, is to force, not to regulate the online gambling operator because they're offshore anyway, but to regulate the internet access provider locally. And then basically put the relevant IP address on a blacklist and then to prevent consumers accessing this. And it's interesting because in a way this is a very crude tool which in many ways can be circumvented, although some people obviously argue that if a gambler gets then a message which they become aware that they might be accessing an illegal site, and that might actually discourage them to go any further. But clearly if you're determined, you can easily circumvent such blocks. So online gambling, I think again here what is interesting about this is that we have restrictive regulatory regimes next to more lenient regulatory regimes, and ultimately it's not so much a question of jurisdiction because clearly the territorial link is the location of the gambler, but it's a question of enforcement. Providers adopt a targeting strategy in both ways, so if you deliberately want to locate gamblers in jurisdiction where it is illegal, or if you want to comply with the law, you just have to basically find out where the gamblers are. And enforcement is attempted through internet access blocking and payment blocking, which have some effect, but a limited effect. Now this slide caused me some concern because I wanted to show you something related to internet porn, and of course when I downloaded this picture, it was a thumbnail, and I wasn't quite sure what it would resolve to. But I think we'll see. So, only about, 20, 30 years, we lived in a world, if you wanted to watch a hardcore porn film, you had to go to a specialist sex cinema. And in terms of age verification, that would mean that if you didn't look, if you looked underage, you simply had to show your ID to prove that you're overage. This world is now obviously gone because anyone, including your 15-year-old teenager, can access hardcore pornography on the various tube sites. And clearly, there's also a generational gap because I think people of my generation and older probably not even aware of what's being out there. Actually, it was kind of funny when I started my role at Outward, the first thing he asked said, "Have you ever watched any hardcore pornography?" And I said, "No, I haven't." And he said, "Here's the DVD, but we don't have to watch that now." And I think a lot of people of my generation and older probably was just not aware necessarily what is out there. And I guess working at Outward kind of was a little bit, in that particular respect, an eye-opener. And I think it's an interesting social experiment, the next generation growing up with this sort of stuff, and what does that actually mean for their own sexual health. I'm not saying people will turn into rapists, but what does it actually mean for their relationship skills, and etc., etc. Maybe humans are adaptable, but I think it's a very, very risky social experiment. So, conventional media, obviously heavily regulated. Television, we have Ofcom's broadcasting standard, very strict standards for content. We have for the film classification, the age ratings for cinema and DVD. And the internet, for a very long time, was unregulated. Especially the UK government arguing, perhaps truthfully to some extent, saying, well, there is nothing we can do. And it was, interestingly enough, it was competition, I think, which drove this area. Competition in the internal market of the EU. So this idea that exactly the same content on television is really heavily regulated. But if you provide exactly the same content online, it's not regulated at all. And you can imagine those people that the broadcasting companies are not very happy about that, because they say, well, our competitors online, they're basically unregulated. We have a massive regulatory burden. And the internal market in Europe being about trade, this was persuaded eventually the Commission to kick into action and pass the Audiovisual Media Services Directive, which was then obviously had to be implemented in the UK. Now, can internet content be regulated in the same manner? No, of course not. So the directive actually applied a lesser standard to online content. So for our purposes, what is of interest here for this particular lecture is the provision which basically says if content seriously harms, seriously impairs the moral, mental or physical development of minors, it has to be provided in such a way that they can't normally access it. So we're talking about age verification and then access controls. We're not talking about censorship as such. Now, interestingly enough, the jurisdictional tests in the UK implementation, the regulations, provide that editorial responsibility must be in the UK before the regulation applies. Now, as a regulator, how do you prove that editorial responsibility is in the UK? You have a company who provides the same sort of stuff which they've always provided. In the old days it was in DVDs, now it is online. And they say, well, we've just outsourced our editorial responsibility to a company in Canada. Sorry, you don't have regulatory competence. So it's very difficult to pinpoint where editorial decisions are made in this particular industry. That might be difficult, it might be different for a massive traditional broadcaster where you know where the people work and where the content is produced and edited. Now, that, I think, is one of the problems. Now, a lot of the content on these tube sites, for those of you who have watched them, I won't ask who has, is obviously free. And the way, just like YouTube, this content is being financed is through advertising. And they advertise all sorts of dodgy services, but also, obviously, subscription services to longer, high-density, better quality films, which then have to be paid for. And the whole idea is that people get so addicted, and I don't mean this in a technical sense, to the content that they're willing to pay for subscription. So the question here is, could we enforce regulation even to out-of-country providers by, again, tapping those payment streams, as we've seen has been done in relation to gambling. And of course, again, perhaps enforcement to a filtering content at internet access level, which again is obviously hugely controversial because of freedom of speech. To what extent does that actually affect, adults' free speech? Now, this is an interesting statistics. Now, obviously, I have not independently verified this. The German paper Die Welt in 2012 was investigating Fabian Tellman, who basically had the biggest porn empire in the world. He owned all the important porn sites. And really his background was in the porn industry. He's an IT specialist who developed a really sophisticated tracking software. That's how he got into this business. Now, Germany, of course, also wants age verification in the same AVMS directive. And so he said, okay, for the .de domain, we better introduce it. So it had 43,000 total users a month. And the .com site, exactly the same content, had 1 million visitors a month. So this kind of illustrates what is at stake for those who write these type of content. So, media regulation. Well, first of all, I think the problem is that the editorial responsibility is tied to, so jurisdiction is tied to editorial responsibility. I think we now see a much more complex and layered distribution chain, as we see in many other sectors, compared obviously to broadcasting. Jurisdiction, therefore, can easily be avoided. And in a way, again, maybe not a jurisdictional problem in a strict legal sense, because, again, the country of destination is here the jurisdictional link. but actually still the pinpointing of the activities and enforcement. Again, some success perhaps enforcing through following the payment streams and blocking, but again it's only partly effective. Now the final point is perhaps the most topical in terms of recent news, and it's obviously a very complex topic. Here I'm only looking again at the jurisdictional aspect, although they're also linked to the privacy concerns. Now, we take it for granted that the police can only enforce the law within the country. I mean, a policeman couldn't go to another country and seize documents or search premises, obviously. But online, I think that's perhaps not as obvious. So I think the jurisdictional principle here means, the territoriality principle means that a criminal investigation and prosecution can only happen against an offender within the state's territory. Otherwise, if state A needs some evidence from state B, for example, they have to go through a formal legal procedure, which is called mutual assistance, usually agreed and contained in international treaties, either a bilateral treaty or multilateral treaty. It's very, very slow, so it takes 3 years, 4 years. I mentioned Fabian Tellman earlier on. He was actually charged with tax evasion, not a criminal provision in relation to content and tax evasion, because that was his other evil deed. And he actually is still, they're still investigating him 4 years later, because they're waiting for mutual assistance from Cyprus and Canada, 4 years later. So it takes 3, 4, 5 years. Now, in a world where crime easily crosses borders, as the internet does, that is clearly not good enough. So in the old days, the police would go in and take a computer away. And hopefully it wasn't encrypted and they had the evidence. Now clearly they might take a computer away, but that doesn't really help very much, because there might be some signs that there's a Dropbox account on that computer, and that's the end of it. So the data is not on the actual machine, the data is somewhere else in a data center, or as we say, as a matter of speech, in the cloud. Isn't that a wonderful cloud? I took this photograph myself, that's the only photograph I have. So there are two changes of paradigm, I would say. First of all, where the data is physically stored. In the old days, it was all about search and seizure. Now it's all about where can the data be accessed rather than where it is physically stored. And the other paradigm change is interception. So in the 80s, when we all communicated by telephone, and the telephones, well, before the 80s, I guess, were operated by national providers, okay, you had interception points, and the security services and law enforcement were listening in that way. But now, of course, we only use our communication service providers to access the internet. And the actual content goes over the top of that. So we actually use over-the-top internet services, you know, WhatsApp, Skype, etc. So these providers are all in a different country, mostly in the US, China, where they are. So how does that square with the territoriality principle? So there are three questions, I think, in my mind. First of all, can law enforcement directly access data in the cloud? Where is that data? So is that a jurisdictional issue there? Can law enforcement obtain disclosure directly from the communication service provider, Facebook, which also is not in the jurisdiction, it's also abroad? And then perhaps even more controversially, can law enforcement then hack into foreign servers where the data is stored? So how does that square with the jurisdiction principle? So here's an example of this. So take a law enforcement authority in England, just by way of example, and they would need access to data on X's Facebook account, which could be either the suspect, which then is the same country, or third party, which is another country. So they want to, in a way, extend the remote search. Now, the other option, of course, is to get the data if it's not encrypted and if the social media operator has access from the social media operator. Now, we've seen, I think this week, there was a story in the news about Apple, and basically the iPhone uses encryption, and it's we all, you know, those of us who have an iPhone, is quite simple. There's a 4-digit PIN code, and you only have 10 attempts. But of course, with a 4-digit PIN code, there are 10,000 possibilities. So in order to do a brute force attack, you need more than 10 goes. And so the US government wants access and basically tries to force Apple now to work with it to change that system. Apple is obviously saying, well, you know, we do this for the security of our users, and if we break it for one, then we break it for everyone. So it affects security, not just against law enforcement, security more generally. And then there's also the question of the physical location of the data being stored, or the information being stored. A data center in Ireland or data center in the US. So it's these access points which are in foreign jurisdictions, essentially. So this is our data center, and I thought essentially there are 5 possibilities. The first, perhaps most important source of data for law enforcement intelligence is obviously open source data. We can all access websites. So the first question is, should law enforcement be able to access websites? Clearly those websites might be hosted and operated in a foreign jurisdiction, but I think internationally it has, at least in the framework of cybercrime convention, it has been agreed that this is not a breach of international law. Second one I already mentioned is, of course, the proper way in inverted commerce, and that is mutual assistance to establish treaty procedures. And again, there's the question, actually, mutual assistance with who? Mutual assistance with the place where the social media operator, or is it mutual assistance where the data is actually physically located, which might not be known, or if it is known. So there's even a question of where do you apply for mutual legal assistance. And then, in a way, the more practical way of going about it is remote and direct access. Now, there are precedences for this. For example, the Belgian Criminal Procedure Code, as well as a Danish Supreme Court case of 2012. In this Danish Supreme Court case, it was a drug investigation, and basically the question was, they needed access to, I think, a Facebook account and a Messenger account. They had obtained the passwords and logins, so an exception which was lawfully authorized under the Danish law, and the Danish Supreme Court said, yes, you can do that, even so obviously the actual account is not in Denmark. The other possibility, which before the Snowden revelations, I think is what usually happened, was voluntary cooperation. Voluntary cooperation by the actual person who controls the account. So I'm one step ahead, I'm step one back. Voluntary cooperation by the company. They came over, they came for the interview, and during the interview demonstrated their hacking skills on the FBI computer. Of course, they did access their Russian account or their Russian computers. The FBI used keyloggers to capture all the passwords, and then accessed the Russian computers, downloaded all the evidence quickly, then got a warrant from the courts, and then obviously used that in court. Now they challenged this, and they said, well, this is actually against the reasonable expectation of privacy, 4th Amendment of the US Constitution. And the court, perhaps unsurprisingly, said, first of all, you had no reasonable expectation of privacy, because you were actually accessing your account from a foreign computer. So you had people looking over your shoulder. How can you say you have a reasonable expectation of privacy? And the other argument was that, of course, the 4th Amendment doesn't apply to Russian territory, so you don't have any protection at all. Now, the other access point, as I said before, is the social media service providers, say Facebook, WhatsApp. As I said, before the Snowden days, some of the social media providers in the US were selectively, voluntarily cooperating with law enforcement. You remember back the iTunes terms and conditions? We all agree that those service providers can disclose our data to law enforcement. That's what this is about, I think. So it's basically the social media providers protecting themselves from allegations by consumers that their data protection rights are being. So that there's a clear clash here. Now the Cybercrime Convention, this is very, very controversial. Basically says that this can happen with the lawful consent. Now, is this lawful? Is there consent? Now, obviously, after the Snowden revelations of 2013, obviously social media operators are much more careful now in respect of voluntary cooperation. The other possibility is using domestic procedures to compel disclosure against a foreign service provider. And we have two, I think, well-known cases in this area. A case, Yahoo. Basically, the Belgian investigator wanted subscriber data. They wanted to know who is the person behind this Yahoo email account. And then used domestic Belgian procedures on Article 46, I think, of the Belgian Code of Criminal Procedure, and served that on Yahoo. And Yahoo said, sorry, we're not established in Belgium. You need actually a US authority under the Stored Communications Act, so sorry, you have to go through mutual legal assistance. And Yahoo, and this was fought all the way to the Supreme Court of Belgium. And the Supreme Court of Belgium said, yes, it is, in this case, it is okay to use domestic procedures against a foreign service provider on the basis that they're commercially present in Belgium, and obviously the suspect, that they're commercially present in Belgium, and so therefore it was sanctioned. But obviously that was 4 years after the actual request. Now, the more recent Microsoft case is a bit more complicated because Microsoft hosts some of the data locally in Europe in an Irish data center, and the US government wanted it to disclose the content of the communication in this Irish data center. So here we clearly have a US law enforcement and we have a US company, but only the data is hosted in Ireland. And obviously Microsoft in recent years has advertised itself as particularly privacy friendly. They market their European cloud as being safe from US law enforcement, so they have a considerable stake in this issue. And the issue actually pivots around the question of what is this under US law? Is this a search and seizure, in which case it's extraterritorial, or is this a pure data disclosure, in which case it isn't extraterritorial? The case has now been appealed, and the hearing I think was in September or October, but the judgment isn't out yet. And then finally there's even more controversially this whole question of hacking into remote computers, which again might be on foreign territory. So in the UK, obviously we have currently the Investigatory Powers Bill, which is obviously a very complex piece of framework legislation with the idea of consolidating the investigatory powers. Now I'm, in this particular lecture, I'm only interested really again in the jurisdictional powers. And it is interesting that the bill contains express powers to oblige communication service providers located abroad to directly cooperate with UK law enforcement, which I think is interesting in terms of jurisdiction. So summing up, well, mutual legal assistance, if you want, is the proper way of going about it, but it takes too long. So law enforcement obviously is crying out for new powers to deal with this issue. There is, I think, a question about extraterritoriality. Clearly, this issue is rightly so discussed in terms of privacy and surveillance and human rights. And the territoriality issue perhaps is a little bit of a sideshow of this more important question, but it is part, I think, of the question of the rule of law. And that's why I personally think it is also important. Now clearly the states have argued that they should have these powers, argue that jurisdiction is based on the fact that they have jurisdiction to prosecute or jurisdiction to bring the suspect before the court, or the fact that they have jurisdiction over the suspect. So if we can prosecute, we should also be able to investigate. Alternatively, I guess it could come under the protective principle, but again, this is very, very controversial. I think the problem here is that it weakens constitutional protections enjoyed by suspects and widens extra legal powers. So I think there is a real issue also with this. So to sum up, well, I think the territoriality is a problem, and I think from a legal sort of doctrinal point, I think we see probably a greater emphasis on focusing on the personality principle and ultimately the location of the person rather than the location of the data. the difficulty is pinpointing actors and activities to a particular territory. One of the side effects of this territoriality principle is also, and the enforcement issues, is the avoidance of law by actually locating yourself in a jurisdiction which doesn't enforce. So the difficulties of enforcement, and I think states ultimately, have to realize that they have less power and therefore must prioritize enforcement resources. Obviously there are attempts in a way to focus enforcement on local intermediaries, such as payment intermediaries or internet access blocking, which then obviously has also implications on freedom of speech. These are only partially effective, and I think in a way, from a lawyer's point of view, there is a real impact on the notion of the rule of law. And I think in a way this is obviously a concern, because at the end of the day, legality is, I think, what democracies are built on, and what does that actually mean? So I think there are much wider implications than just fine legal doctrinal points. And that's where I stop. Thank you very much for listening.